Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery Today's Doug Austin. The important case law decisions for April 2022. Our faculty experts are, of course, the aforementioned Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel. This webinar will be recorded and available for replay at your convenience, as will every month's webinar. Please take a look at our attachments tab for a link to eDiscovery Today to subscribe there. To learn more about engaging Judge Peck and Tom O'Connor's spicy techno gumbo. We also have a registration link for next month's case law webinar for your convenience, and you can download a certificate of attendance from the console after the webinar for your use in your continuing ed requirements. Now, Doug Austin, he is the editor of our EDRM partner, eDiscovery Today. Doug has over a decade of experience in the trenches of eDiscovery, posting at least once, sometimes 3 times each business day since 2010, and yesterday celebrated the 2nd anniversary of his wonderful blog. Doug earned the Reader's Choice Awards from JD Super and eDiscovery in cybersecurity back a couple years ago, which he will win again in 2022 as EDRM will be posting some of his content and submitting to JD. And Doug is graciously honored us with some of his fabulous original content. Thanks, Doug.
Thank you, Mary.
And Tom O'Connor, hailing from the great city of New Orleans in the home stretch to Jazz Fest and a crawfish boil. For 3 decades, he has stewarded the Gulf Coast Legal Technology Center. He's a sought-out consultant on some of the largest cases, most recently the opioids, and he co-hosts the extraordinary YouTube interview format channel with the wonderful Rocky Messing. And our Honorable Judge Andrew Peck retired as a federal magistrate judge in the Southern District of New York after 20 years, writing many of the first opinions, some of which had subject matter on some of these later cases. It will be very interesting to hear his thoughts. Some of those cases where he wrote the opinions include eDiscovery generally, keyword search terms, boilerplate objections, 502D orders, and of course, technology-assisted review. He's a graduate of Duke Law School. Now with DLA Piper, he advises on information management, particularly in the eDiscovery context. He also acts as a mediator, arbitrator, and special master. Judge Peck received the 2022 Honorable Shira Shindland Lifetime Achievement and eDiscovery Hero Award presented by Zapproved, an EDRM Guardian Plus trusted partner. EDRM is grateful to all 3 gentlemen for serving on our EDRM Global Advisory Council. So, Doug, do we have a few cases today?
We do, Mary. We have another 6 interesting cases this month, and they include a third-party subpoena jurisdictional dispute, a dispute over forensic imaging, the use of file shredder software, and potential sanctions. I think we can predict how that one will turn out. Potential waiver for disclosure of privileged materials, and court-ordered production of entire custodian email boxes in discovery. We also have a case ruling from one of our favorite judges, Illinois Magistrate Judge Jeffrey Cole, which was a case suggested by Judge Peck. As always, we'll look to hopefully save a few minutes at the end for questions, but we encourage them along the way as well while we're discussing each case. I should also mention that you won't see the slides among the attachments, but we will follow up with an email after the webinar with a link to those. So look for that after the webinar. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. Failing to say that might get us sanctioned by them.
Ooh, I see what you did there.
Indeed. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery Today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 22,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. In fact, they've added 9,000 cases in the 21 months since we started doing these webinars. eDiscovery Assistant is a definitive source for eDiscovery case law out there. So with that said, let's get into the cases. In Goodloe Marine versus BC Towing, a dispute over tugboat towing services where the tow sank and there were claims and counterclaims related to the accident, the court granted in part a motion to compel in September 21 and ordered plaintiff Caillou Island Towing Company to produce documents related to the tug's towing logs and limited the production to the past 3 years. The order noted Caillou agreed to allow third-party defendant RJA Limited's IT expert on board the tug to extract the electronic charts for the voyage in question from the Rose Point compass system. The inspection of the Rose Point system, the logbooks on the tug was scheduled, then rescheduled after Caillou failed to confirm the size of the hard drive on the computer. Caillou then subsequently informed RJA that certain data on the Rose Point system was no longer readily accessible. According to RJA's expert, to uncover the data, the computer hard drive needed to be mirror imaged. But Caillou canceled the inspection, stating it couldn't allow the tug's hard drive to be mirror imaged without consulting its IT expert to determine if there were other ways to obtain the information. According to RJA, Caillou failed to provide an alternative date for the inspection or alternative procedures for obtaining the deleted data, leading to a motion to compel by RJA. Florida Magistrate Judge Amanda Arnold Sansone stated in granting the motion to order Caillou to allow forensic imaging of the computer hard drive. As noted in the court's September 2021 order, Caillou agreed to allow RJA's expert on board the tug to extract the Rose Point electronic chart for the subject voyage. Although Caillou's response suggests there may be other ways of obtaining this information, it appears no effort has been made by Caillou to do so. Given the failure by Caillou to provide RJA access to the electronic chart and tow logs, an order compelling the disclosure and allowing the parties access to the tug is necessary. Tom, do you think that the forensic imaging would have been ordered if Caillou hadn't kept postponing the inspection?
Well, I think it wasn't just the postponing, as you mentioned there in the synopsis. At some point during one of the postponements, they indicated that data was, quote, no longer accessible, end quote. And in what I read, the order that I read, they didn't specifically say what that meant. However, the judge did say in the order, the judge mentioned that that mirror imaging, a forensics image was being ordered because it will find quote, deleted or overwritten files, allocated or non-allocated data, and slack space, end quote. So we can assume that the non-accessible data fell into one of those categories. So I think the concern by the judge was that data was if not disappearing, becoming non-accessible, shall we say.
Sure.
And so it wasn't just a postponement to, oh, this isn't a good day for us, let's try it again next month. It was, oh, and then in the meantime, we don't seem to have some of that data. So I think there was a concern regarding that really prompted the order.
Yeah. Although, Tom, if I can jump in, I mean, it wasn't clear. It wasn't clear to me whether the data would have already have disappeared at the time of the first inspection, but that Caillou, or however you pronounce it, didn't know that until later, or whether the data would have been there had the inspection not been postponed, and in the course of time, whether from negligence or from something more nefarious, no longer exists.
I wish there had been a little bit more discussion of what was meant by no longer accessible and how that happened. Yeah.
Sure.
And when.
Well, and I think it probably didn't fully know what was still available. Because obviously once it becomes not primarily accessible, you don't know how long it's going to be there. So I'm sure in some cases that probably didn't have a way of knowing. I think it's notable, Judge Peck. Certainly, RJA's expert stated that mirror imaging was necessary to recover the data. How much importance did you put into expert statements regarding technology considerations when you were a judge?
Expert statements in discovery disputes? If only, more often, 80, 90% of the time, it was the lawyers saying what they think they knew and understood. But in cases where there were experts about the discovery issues, they're obviously very important. And all kidding aside, it would have been better if more of the cases in front of me or more of the cases in front of the courts involved experts, because, when the experts speak, obviously there are experts like Tom and there are experts who are not so expert, but it's better than, lawyers trying to say what they think they know. No offense to the lawyers, but I'd much rather have an expert helping me out.
Yeah, makes perfect sense. Mary, obviously we've seen plenty of cases requesting forensic inspections. Some don't always get that. So what advice do you have for our audience regarding what steps they need to take to request forensic imaging of an opponent's media to increase the likelihood of the request being granted?
Yeah, and this is just to increase the likelihood. But first of all, the type of case should warrant it. Maybe a trade secret, whistleblower, fraud, something like that, or the type of data. And in this case, it's data on a boat. We've seen a lot of oil rigs or things like that. Some places where it's hard to get to the data, where forensics imaging is granted just because of that. Have good behavior on your side. So if you're a bad actor, probably not going to get forensic imaging on the other side. Make reasonable tailored requests that pertain to the claims and defenses, and then describe what you're looking for in particularity, and then document the other party's noncompliance. You can get your request baked into an order, like the scheduling order, so that when they're not compliant, they're violating a court order. And you can also offer to pay for it. And I would say offering to pay for the imaging only, so that you've got a preservation copy. That's fairly inexpensive. The analysis can get into some bigger bucks, and then offer up a neutral. To remove objections that, by your imaging the drive, you might see privileged material or sensitive material or something like that. So those would be my suggestions there.
Those are some great suggestions. So absolutely, those are some of the things it seems I've seen in the cases where they have been granted. So great points there, Mary. All right, we'll move on to our next case. And usually the disputes we cover involve what has happened or what needs to happen. But in our next case, it involves where it needs to happen. In Steel Supplements versus Blitz, Nevada, a contract dispute regarding nutritional supplements, the plaintiff argued that the discovery sought from third-party Ignite was subject to a previous ruling by the issuing district in Florida on a motion for a protective order, also arguing that having the Florida court rule on the motion would obviate potentially inconsistent rulings, and that the only ties that Ignite had to Nevada was that its counsel and an executive, Dan Bolzarian, who was also the sole owner of Blitz, the defendant, reside there. Ignite argued the only reason the plaintiff wanted the motion to be decided in Florida was to avoid Ninth Circuit precedent, which, according to Ignite, holds that Ignite's parent company would not have to comply with the subpoena. Ignite also argued that the Florida court had not made any substantive rulings on the matter, and it argued it would be costly for Ignite to have to hire counsel in Florida, given the current counsel for defendant Blitz can only pro-hack on behalf of Blitz. The plaintiff, in response, argued the transfer would not impose any undue burden on Ignite, citing Rule 45F and arguing there's no prohibition to Blitz's counsel appearing on behalf of Ignite in Florida. She was already familiar with the local rules, and hearings had been taking place telephonically. The Nevada magistrate judge Brenda Wexler stated, although the party that wishes to enforce the subpoena must initially move the court for the district where compliance is required, Rule 45F gives the court discretion to transfer subpoena-related motions to the issuing court. In granting the plaintiff's motion to compel non-party Ignite to comply with subpoenas, with those matters to be resolved in the issuing court in Florida, Judge Wexler stated, the court finds plaintiff has demonstrated that exceptional circumstances exist for this motion to be transferred to Florida. First, there is minimal burden to Ignite. Counsel for Ignite has already responded to the substantive arguments regarding the motion to compel. She's familiar with the case as she represents defendant Blitz in the underlying case, and she'll be able to enter an appearance in Florida as counsel for Ignite. In addition, the district court in Florida is in a much better position to rule on the instant motion, as it has already entered orders implicating similar relevance and proportionality arguments the court would have to undertake here. The Florida court subsequently granted the motion to compel and issued several rulings related to Ignite's failure to participate fully and robustly in discovery related to the instant subpoena. So, Judge Peck, how common is it for a party to issue a subpoena in a different jurisdiction than the one where the case is being conducted? And how would you decide whether to grant the request for it to be transferred?
Well, it's very common because that's what Rule 45 requires.
Mm-hmm.
Rule 45, as amended, requires that the subpoena is issued out of the court where the action is pending. In this case, out of the Middle District of Florida. But compliance, that is the deposition, or to the extent documents are produced where located, as opposed to, ESI just being transferred over. But the compliance is where the witness lives or is employed, in this case, Nevada. So exactly, what was done in this case is what the rule requires. The reason the motion to compel or quash is made in the court where compliance would occur, that is Nevada, is for the convenience of the non-party, which in most cases is a true non-party, not a non-party, but closely related to a party. So the Rule 45 says if either the subpoena recipient consents to the transfer, that didn't occur here, or there is, quote, exceptional circumstances, a nice vague standard, that it can be transferred to the issuing court. The principal concern is fairness to the non-party witness who and its counsel may be very far distant from the issuing court. I will be curious to see how that plays out, since COVID, where, as was noted in the judge's opinion, many of the proceedings in the Florida court were being done not in person, whether video or telephonic or whatever. That may change the issue of burden to the non-party. So was this an exceptional case? I'm not sure, but it also was one where Ignite and its counsel clearly had a very close connection to the issuing court in Florida. So it's not surprising that the case was transferred.
Sure, that makes sense. Well, and Judge Peck, you brought it up. So, Mary, how important do you think the fact that the sole owner of the defendant company was also majority shareholder of the third party being subpoenaed? Do you think all third parties should be treated the same when some are very closely tied to the parties in the case, like Judge Peck mentioned?
No, I think certainly economic ownership and constructive control, would be important. They talked about the corporate shell game and things like the Ignite only had one director. They attempted to hide some data in Canada. They didn't search certain sources, and so they had some bad marks against them already, and then they've got the their ownership structure, their entity structure. So but no, I don't think all third parties should be treated the same.
Yeah. Well, and speaking of bad marks against them, Tom, the Florida court called, the link at the bottom there goes to that ruling, and they called Ignite's handling of discovery gamesmanship and a corporate shell game. And their 30B6 witness had been at the company for all of 36 days before being deposed. So should it really have mattered where the motion to compel was decided, given that lack of cooperation?
Well, I think it did matter for reasons that Judge Peck just outlined regarding Rule 45F. And you had some of the quotes from Judge Wexler's order there that talk about that. She went into a pretty detailed reasoning of why she was basing it on 45F. And she closed that with, or ended it up with, a quote that said, the parties appear to disagree as to the meaning of a temporal limitation imposed in discovery by the issuing court. Thus, transferring this motion to the issuing court would avoid the potential for inconsistent rulings. In short, then, the circumstances favoring transfer outweigh the interest of the non-party served in obtaining local resolution, end quote. I thought that was really telling. Mm-hmm. There had been hearings, conducted telephonically, as Judge Peck noted, but there were things had already been going back and forth, if you will, and I think Judge Wexler quite clearly said, I don't want to open the door to inconsistent rulings, which are going to muddy the waters even further. 45F gives us the authority to do this if there's exceptional circumstances. This qualifies as such, so I'm sending it back home. And I think that outweighed the significant issues of lack of cooperation.
That makes perfect sense. All right. Thanks, Tom. All right. So we'll move on to our next case. And it's one there where we previously covered a ruling on the parties' negotiation of a Rule 502D order, albeit with a different name to Facebook's name change to Meta Platforms. So here, the plaintiffs moved to compel defendant Meta Platforms to produce in unredacted form 9 emails or portions of emails labeled R1 through R9 that were part of an extended email exchange that Meta clawed back from production, asserting attorney-client privilege pursuant to the parties' 502D clawback order. They were among approximately 12 million pages of documents that Meta previously produced to the FTC, which were also produced in this case. Meta clawed back the emails back from the FTC after being alerted that they were potentially privileged and sent a clawback notice to do so in this case as well. California Magistrate Judge Virginia DeMarchi addressed several arguments from the plaintiff regarding waiver of privilege. First, he concluded that the disputed emails were made for the primary purpose of giving or receiving legal advice. Second, regarding the plaintiff's argument that the communications were not privileged because they included a non-Meta employee, Rebecca Hahn, a partner at a marketing agency, Judge DeMarchi stated in rejecting that argument, in this instance, Ms. Hahn's apparently passive role in the disputed communications did not directly serve the interests in the attorney-client privilege protects. At the same time, however, Meta has shown that Ms. Hahn had employee-like duties and responsibilities for Meta over many years. She also addressed the plaintiff's argument that production of the email exchange in unredacted form to the FTC in 2019 waived any privilege that otherwise may have been protected, protected the disputed communications, stating, Meta simply has not explained, either in a supporting declaration or in its opposing brief, what it actually did to prevent disclosure of privileged information in the first place. Nevertheless, the court may fairly infer that a disclosure of 9 privileged communications from a document production of more than 12 million pages reflects that Meta did, in fact, use reasonable steps to prevent disclosure of privileged material to the FTC. However, Judge DeMarchi stated in ruling privilege was waived on one communication that was included in a complaint in the FTC case. The court is disappointed that Meta did not share this information with plaintiffs during the parties' discussion and did not disclose it in briefing before this court, as it's material to the court's resolution of this dispute. Meta has allowed a portion of redacted communication R5 to be disclosed to the FTC and to the federal court in the District of Columbia. The fact that the disclosure is confidential and under seal does not matter. Meta has agreed to permit the use and disclosure of a communication it contends is privileged. This is a voluntary disclosure. So, Mary, absent a 502D order, should an inadvertent disclosure in one case lead to waiver of privilege in other cases?
This is an interesting case in question. Privilege isn't a given. Certainly where you are in the world, and state by state, you have different considerations there. It's not absolute, and there are ways with protective orders and good documented privilege processes, or, as the court said, the numbers of the overall production, and then amazingly 300,000 were designated as privilege, which seems kind of high, but that they had less than 10 that they wanted to claw back. You can make an inference that maybe they did have a good process, but certainly, and I think all of us on this call would agree, taking the 502D route is the safest way.
Yes.
502D? What's that? I've never heard of it.
502D.
I think one would agree even more than most. For sure. So, Tom, are you surprised? Tom, Judge DeMarchi made such a big deal over Meta's lack of explanation over why the 9 email communications were inadvertently produced, given that they were part of a 12 million page production. You think that was, she really almost sounded like she was going to rule they were waived, but then ultimately still said that privilege wasn't waived. Are you surprised by that?
Well, as I started reading it, if you look at just the numbers, like 9 out of 12 million, that seems sort of surprising. But I think the crux of her ruling is in the last paragraph of your synopsis, when she talks about the matter in front of the FTC. In fact, what happened was that a portion of one of those communications, and I have to assume that they were linked somehow, was included in a complaint filed in the action, and that the FTC and Meta jointly agreed that the FTC could include a portion of the redacted communication in the substituted amended complaint in that particular matter. So the court expressed what it called disappointment that Meta did not share this information with the plaintiffs during the discussion. You never want to disappoint a judge, right, Judge Peck? That's like bad. When the judge says she's disappointed, nothing good is going to happen after that sentence.
That's my usual reference to Rule 1.1.
1.1.
Not written down, that is, don't piss off the judge by your conduct.
Exactly. So, and then she went to great lengths to say at the end of that paragraph in the order that the fact that the disclosure was confidential under seal does not matter. Meta agreed to permit the use and disclosure of a communication it now contends is privilege. This is a voluntary disclosure. As we say in New Orleans, bam, end of discussion.
Yeah, absolutely. Yeah, and that seems to be almost really kind of a no-brainer. So Judge Peck, Judge DeMarchi conducted her evaluation of waiver of privilege based on Rule 502B. But had the documents been produced to the FTC after they'd been produced to the plaintiffs, would they have automatically been protected by the 502D order in this case?
Well, they would have been protected in this case. Whether they would have been protected in the FTC case would have been decided by the judge in the FTC matter. I mean, here the court had to rely on 502B as in boy, because the documents were produced to the FTC before the court here had entered the 502D order, and the FTC regulations essentially incorporated 502B. So that was the operative rule as to whether there was a waiver before the FTC. Had production occurred to the FTC after production to plaintiff, in this case under the 502D order, it would have been a much more complicated question as to whether that production to the FTC did or did not amount to a waiver, in this case under 502D. There is a concern, and as is often the case, going to the advisory committee rules often sheds light on federal rules, whether civil procedure or evidence. And in the congressional comments that are the equivalent of the usual Rules Advisory Committee notes, there was concern about producing material to a government entity, to try to get favor from that government entity and avoid criminal or other major penalties, but withholding it from civil plaintiffs thereafter. It's, you can't use your protection as both a sword and a shield.
Right.
So that is likely something that would impact things here.
Yeah, that's a great point. And I thought it was really an interesting walk through the various aspects of potential waiver of privilege in this case. So it was, I thought it was a really well done discussion of the different considerations. So, so thanks, and we'll move on to the next case. And I mean, let's face it, our next case illustrates, not surprisingly, that the use of file shredder when there's a duty to preserve is a very bad idea. GMS Industrial Supply versus GNS Supply, you'll see in a moment that the similarity in names is not a coincidence, is a case involving a former director of sales of the plaintiff who formed a competing company while still employed by the plaintiff. When the plaintiff discovered the existence of the new company, it sent a letter to eventual defendant Wesley Greer on April 3rd, 2019, informing him of his legal obligation to preserve all potentially relevant information. In a subsequent letter on April 17th, the plaintiff directed Greer to return its property, including a laptop, desktop, and a computer tablet. When they received the equipment, they discovered that 24,000 user-created files had been deleted from the desktop about half after Greer received the litigation hold letter, and the computer tablet was password protected, but the password that was provided by Greer didn't work. Unfortunately, that's not all. After receiving the second letter, it was shown in a forensic inspection that Greer attached the USB storage device to the desktop computer and accessed documents on the device. He then ran a Google search for the term file shredder, visited the file shredder website, and downloaded and installed file shredder. After the installation, Greer ran the file shredding program, permanently deleted 3,397 files from the computer, and then uninstalled the shredding program. Not surprisingly, the plaintiff filed a motion for sanctions. Noting that defendants agree that plaintiff can establish the first and third elements that ESI should have been preserved and that the loss was due to Greer's failure to take reasonable steps to preserve the ESI, Virginia District Judge Roderick Young observed that Greer downloaded 21 DLA files, and the file names indicated that the downloaded files likely concerned competitive sales made by G&S to customers or potential customers of GMS, and that there were 481 of the 3,397 files destroyed by file shredder for which the forensic examination was unable to even recover the names of the files, finding that the DLA documents and the 481 permanently deleted files are both lost and irreplaceable. Judge Young also stated in granting the motion and ordering an adverse inference instruction against Greer, instruction sanction against Greer, Greer's actions demonstrate an intent to deprive plaintiff of use of the information stored on his desktop, Despite the clear instructions to preserve potentially relevant documents and information as discovered by the forensic examination, on April 19th, Greer proceeded to download File Shredder onto his desktop and destroyed all the user-created files. In a separate motion, Judge Young also denied the defendant's motion for sanctions against the plaintiff for its claims against former defendant Sky Spires, citing Rule 11's safe harbor provision that prohibits sanctions if the challenged paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days of service, which the plaintiff did, and withdrawing its filing against Sky Spires within those 21 days. So, and you're right, I'm not showing the correct slide. My bad. I'm sorry about that. I clicked one too many. So Tom, this isn't our first case we've covered like this. Last year, we covered the Liatis case where a party used CCleaner and it deleted 41,000 files during that case, but wasn't sanctioned. Why do you think this instance warranted sanctions when the other one didn't?
Well, there was a clear distinction, I think, in the facts of the two. In this case, the court found there was a definite intent to deprive. What was the date? April 19th, 2019. The Greer proceeded to download File Shredder onto his desktop. This is after an examination conducted by the expert BDO. He proceeded to download File Shredder onto his desktop and destroyed all of the user-created files. So clearly, after there was a duty to preserve, the relevant product was loaded and used. In the older case, the record supported that the plaintiff did not intentionally destroy evidence. And that one, you may recall, Doug, the product had been loaded according to both of the experts for both parties who did their investigation, that the product had been loaded prior to the case firing up and that it was running automatically. That is to say, every time a computer was switched on, the program would automatically delete certain files and clean the hard drive. So there was no definitive intent to deprive in the older case. So I think that's the bright line. Is the product being used clearly, and there didn't seem any doubt in the GMS case that was what was going on.
Yeah, absolutely. And I think that's a notable difference. A great point, Tom. With CCleaner already being on that party's laptop in the other case and just having automatically run versus this one where clearly the defendant was taking steps here, installing the software when the duty to preserve occurred and deleting files was a definitive difference. So yeah, absolutely. Great point. So, Judge Peck, because of Rule 37E2, is it safe to assume that intent to deprive always means the opposing party was prejudiced by the loss of the information?
One can answer that as either just yes, or really it's, sort of statutory construction. The need to show prejudice is one of the elements under 37E1. It is not an element under 37E2. The intent to deprive has historically been considered as the evidence destroyed is bad for the spoliating party. So both as a matter of statutory interpretation, rule interpretation, and the logic behind it, it is not necessary to show that under 37E2. However, again, remember that all of the 37E1 or 2 provisions say the court may. So obviously a judge could take that into consideration in deciding what sanction is appropriate under 37E2. But, essentially, when intent to deprive is shown and when it's shown as clearly as it is here circumstantially, there's no reason for the court to be merciful to the spoliator.
No, that's for sure. So Mary, if Defendant Greer had used File Shredder to delete the files before receiving the letters, do you think he might have been able to avoid sanctions, or would it still have been intent to deprive because he could have anticipated litigation?
Well, it depends. And there is another fact in here that he deleted the program that, the shredder program after he went ahead and deleted everything. That might demonstrate some intent. But not every employee departure, even to a competitor, results in litigation. But Greer might have been on notice that litigation was possible if it was spelled out in his employment documentation, the employee manual, or things of that nature. But I think clearly, we've seen that information governance, where you're actually taking care of your system and cleaning your system, you're doing it for reasons other than litigation. You get a nice pass there many times.
Sure. And we have a question from the audience. What evidence would this panel expect to see for a legitimate non-spoliative use of file shredding software? Certainly the case that I referenced in my question to Tom, the Liadis case, Liadis, which you can find on eDiscovery today if you do a search for it in the term search, is an excellent example of a case where file shredding software, in this case CCleaner, was used, but it was already there existing on the party's hard drive before the case ever began. So that was certainly a great example of one where it was non-spoliative, it was legitimate, it wasn't, it didn't relate to the case itself. Any other thoughts on that question from any of you all?
I mean, just as a follow-up to that, it's, was there a business need for the use of file shredder or CCleaner or evidence eliminator or any of those programs, similar to, is there a real business need for disappearing messaging apps or something else, as opposed to use of those type devices or procedures when you're in the midst of litigation?
Sure, absolutely. Obviously, there's a need to, as Mary mentioned, part of a good InfoGov program, eliminate redundant, obsolete, trivial information within an organization is a legitimate use of a software that might do so. But obviously, the parameters change when there's a case. So, great question and interesting case to talk about. All right, so we'll move on to the case that obviously I can't wait to move to because I had already moved to the slide. So what is more fun than a case involving sanctions for using file shredder? It's a case involving Illinois Magistrate Judge Jeffrey Cole taking parties to task for failing to cooperate. In Deal Genius versus O2 Cool, Judge Cole represented the discovery dispute between the parties this way. Rather than take the opportunity of settling their email dispute at or before the hearing, the parties chose to file briefs on the matter. That the dispute was far better suited to a hearing is illuminated by the parties' filings. Plaintiff's counsel spent 2/3 of its brief complaining about defendant's counsel's performance in the parties' 37.2 conference and the pointless exchanges of angry emails, which unfortunately, in all too many cases, have come to typify the odious exchanges between adversaries. Defendant's counsel, I like
Odious.
Odious. That's your word of the day.
That's becoming my new favorite eDiscovery quote.
There you go. There's more. Defendant's counsel spent half its brief complaining about plaintiff's counsel's performance at the same Rule 37.2 conferences and the same exchanges of angry emails. The attorneys even disagreed over what happened between them at certain points in their months-long squabble. It is the attorney version of the children's taunt, "I know you are, but what am I?" Unfortunately, it is all too common and unnecessary and seems to be even more common in discovery disputes like this one. As such, a tedious summary of counsel's competing versions of what occurred is unnecessary and unhelpful. Addressing the dispute directly, Judge Cole stated in denying the defendant's motion to compel, it should go without saying that months of arguing over 5 search terms and then involving a court in that dispute in any event would be out of proportion to the needs of many cases. But there can be no dispute that what has gone on thus far in this particular case is out of proportion with the needs of this particular case and the commands of good sense. The attorneys in this case are essentially at square one. They have not whittled their dispute down far enough for meaningful court intervention. He also stated that selecting search terms that might assist in locating pertinent documents is counsel's job, not the court's. In a footnote, Judge Cole also floated the idea of using a special master to help with the dispute, stating, given the issues at stake in the case, it is likely more fair to have the parties bear the cost of their discovery dispute rather than as a taxpayer subsidized matter. Review of thousands or even hundreds of documents would monopolize the court's attentions and be patently unfair to the other litigants waiting in the queue, most of whom have honed their discovery disputes through the meet and confer process to far more manageable levels long before discovery closed. So Judge Peck, as I just said, Judge Cole stated that when there are hundreds of documents in dispute, it's appropriate to engage a special master. When did you consider engaging a special master in your cases, and what parameters factored in the decision to engage one?
Unfortunately, or fortunately, the practice in the Southern District of New York was rarely to use special masters. Instead, we poor magistrate judges were tasked with dealing with all of the disputes, petty and otherwise. So, I mean, in 23 years on the court, I appointed a special master only twice. Once, relatively early in my career, when there was dispute over whether the documents on a privilege log were indeed privileged, I followed my usual procedure. I took, 10 or 20 samples from each side, gave them my rulings, and said, now go apply that to the rest of the multi-thousands in dispute. And one of the parties looked at me and said, oh no, Judge, we are entitled to eyes-on judicial review of every one of these documents. To which I responded, well, okay, but it's not going to be my eyes. You're going to pay for a special master. And I appointed a former magistrate judge who had just left the bench, and she had the task of doing that. Fortunately, she was paid by the hour. I would not have been as a judge. The second one, which was near the end of my time on the bench, was dealing with validation in the Rio Tinto tar case, and I convinced the parties, took longer than I thought to convince them, but that they would be much better off if I appointed Maura Grossman as a special master because of her expertise, and she could resolve things with the parties over that. I love Judge Cole's opinions, even though I've never met him and don't know him. But, using the economic threat of a special master's cost is not perhaps the best way to, resolve matters or get parties to think about using special masters in courts where it's more often used. I mean, a better approach is you all have been fighting forever, having a special master helping you through this. And if helping doesn't work, ordering certain things will ultimately save you money because it'll save the cost of legal fees. I'd prefer that approach, but I guess now I would say anything that gets a special master appointed, particularly if that special master were to happen to be me, is a good thing.
There you go. Well, and yeah, it's a great point right there. That's the key. You got a dispute, and they're not making any progress, and they're going to save costs in the long run by utilizing a special master. So Certainly a great point. Quick note, I see a question about the slide deck. Yes, I will be sending out a link to the slide deck to all attendees after the webinar, so you can look for that. So Mary, one of the things Judge Cole stated is that it cannot be denied that in the world in which we live, emails of a party's employees may be the most compelling form of evidence. Do you think that's still true in the world of increased collaboration and use of mobile devices?
Well, he did say the word may be the most compelling form of
Fair
evidence.
point.
So I guess it's true, but if you want to talk about what might be more compelling, how about a video recording of a Zoom or Teams meeting, voicemails where you're actually hearing intonation and, that type of thing. Email is just words on a page. It doesn't communicate sarcasm or any of those other types of emotions. So some other things that might be even more compelling: location data that's in your phone, photographs. The chats and Slacks are even more casual than email. So I think there's more compelling forms of evidence out there.
Yeah, certainly beginning to be more and more. And those are great examples. So Tom, Judge Cole also stated that selecting search terms is counsel's job, not the court's. Are most counsel qualified to select appropriately scoped search terms?
Well, this case just kills me. I mean, come on, man. Let's go Monday Night Football on you here. What were we talking about here? 5 search terms, right? That they had made no headway on for hundreds or thousands of documents. We're not talking about, an opioid case with millions of pages of documents being produced here. I was involved in a case in New Orleans where, there were millions of pages of documents and both sides have been arguing for months. In this case, the judge said they had gotten to square one. He compared them literally to kindergartners taunting each other with, what did he say? This is the legal version of "I know you are, but what am I?" And let's be clear, this was not some really complicated, obscure patent on a pharmaceutical formula. The dispute here involved, and this is from the record, plastic battery-operated fans that dangle around one's neck on a lanyard. The parties each make them. The lanyard on the defendant's little plastic fan is attached to one corner of the fan so that it hangs on an angle. The lanyard on the plaintiff's little plastic fan is attached to both sides so the fan hangs straight. Really? Really? That's the complex patent that these people can't come up with a search term on? I'm sorry. I'm just aghast. I mean, I'm amazed the judge did just. I don't know. I can't say anymore.
Apparently, Judge Cole. Oh, I was going to say. Apparently, Judge Cole was not a fan of how the attorneys.
Sorry. There you go, Doug.
Oh, Doug.
Go on. All right.
What I was going to add is that it clearly isn't the court's job to do it. As some of the cases we looked at a few months ago say, if counsel can't do it by agreement, then they should get experts to deal with this. I'm not sure I go that far, but it sure isn't the judge's job to come up with the search terms.
I couldn't agree more there. So for sure. All right, we'll move on to our last case, which is a bit of a head scratcher, at least to me. We'll see what the panelists think here in a minute. Edwards versus PJ Ops Idaho is a case involving former drivers for certain Papa John's Pizza franchise locations and claims of violations of the Fair Labor Standards Act and relevant state wage laws by improperly applying a tip credit to delivery driver wages and by failing to adequately reimburse delivery drivers for their delivery expenses. The plaintiffs filed a motion to compel, seeking the production of the entire email mailboxes of the sole manager, Tom Wiley, and operating partner, Dougie Allen, of all or most of the Papa John's entities in the case, and also application of several search terms you see listed there to 12 custodians of certain records. So you might scoff and think it's crazy to expect the judge would grant a request for entire email mailboxes in discovery, but Idaho District Judge David Nye, while noting that the defendants would need to review 225,000 additional documents from defendants Wiley and Allen, stated this review would require an estimated additional 3,050 to 5,450 hours of contract attorney and case team review for an estimated additional cost to defendant of $140,000 to $235,000, or 2 to 3 times the cost of defendant's prior review. The review would require 15 people working full-time for 1 or 2 months. And while large, this request is proportional to the needs of the case. Although defendants are correct that the broad nature of the term employer does not excuse the specificity requirements of Rule 34, it does inform how narrow a request for production can be. Here, there are a variety of situations in which Wiley and Allen could demonstrate their authority within the company, each of which would contain a different variety of keywords and phrases. Consequently, drivers cannot restrict their search to a specific set of keywords and phrases in this situation without hampering their ability to demonstrate that Wiley and Allen were in positions of authority over the drivers. Given the criticality of determining who the employer is and the lack of viable alternatives presented to the court, it is appropriate to compel production of Allen and Wiley's entire email mailboxes. Judge Nye also granted the request for search terms, stating, defendants claim that the driver's search terms will be unduly burdensome, pointing to the high cost of producing such information. However, defendants' cost estimates lacks credibility. Defendants originally claimed that reviewing driver search terms would cost somewhere between $41,000 and $63,000. Now, however, defendants claim that such a review would cost between $72,000 and $118,000. Even allowing for inflation, rising attorney fees, and errors in the original estimate given to plaintiffs, the near doubling in cost makes little sense and undercuts defendants' claims that the search is unduly burdensome. Thus, it seems likely that defendants' actual cost of following such a review will not resemble their gloomy prediction of review costs. In other words, he's a skeptic. So, Mary, do judges not get junk mail, or does ordering production of entire email boxes seem a bit over the top here?
Oh, I have a feeling judges do get lots of junk mail, but I think certainly they say that the defendant's proposed search terms do not include Allen within the search, which is especially troubling considering that Allen participated in setting the driver reimbursement rates. So it was a key custodian applicable to claims and defenses that they're looking for that they left out. But regarding junk mail, I mean, who among us does not now have a junk mail filter so that you could pre-tag those things, or a domain filter for things like sports tickets and news? And it also seemed like they could have taken a sampling approach or a more time-limited approach. They didn't offer any alternatives. So is it over the top? Probably not.
Okay. So, Tom, at a cost of between $140,000 and $235,000, does this seem proportional to the needs of the case to review the entire email mailboxes of 2 custodians? Or do you think Judge Nye thought, as he did in the other instance, the defendant's estimates were overstated?
Well, I think that's pretty clear. He didn't overstate it. He said they lacked credibility. That's pretty strong language, and then went on to say the most current cost estimate they gave makes little sense and undercuts their claim that the search is unduly burdensome. So it didn't seem like he was giving any credibility to their numbers. And furthermore, he went on to say that their search terms were unreasonable. Quoting, defendants' proposed search terms unduly narrow the scope of discovery and may lead to relevant emails remaining undiscovered. End quote, the key name that was missing. I think the point here was, if you can't give us something reasonable to work with, I'm just going to throw the whole thing at you and have at it. Not quite as bad as the case before us, the Deal Genius case, but I think we're dealing with what the judge thought were not particularly cooperative counsel.
Sure. That seems definitely a case, a true case there. So And certainly the terms that the plaintiffs suggested, I see at least one, what I call superset term, where Milestar is a superset of Milestar and delivery. So their terms weren't exactly ideal either. But
Yeah.
But what can you say? So Judge Peck, Judge Nye referenced the lack of viable alternatives presented to the court as factoring into his ruling to have the entire email mailboxes be produced. Was this a case of he had no choice, or could he have ordered the parties to negotiate further like Judge Cole did in the last case?
I mean, the problem, and I saved this comment for this question as opposed to against Judge Cole, is, you send parties back to negotiate further is probably, by the time they've gotten to file a motion before the court, et cetera, an exercise in futility. All it means is that, a month later or 2 months later, they're likely to come back to the court and say, we haven't made any progress. The Judge Nye could have ordered them to hire Tom or some other expert to, as some of the keyword cases we've seen before dealt with. But, whether it goes back to the umpire nature of judges, a la Chief Justice Roberts, to a certain extent, Party A presents one alternative, Party B presents another, and the court picks the one that he or she thinks is most reasonable. Some judges would say, yes, but what about this alternative or that alternative? But, probably the only alternative here was good search terms. And clearly, if the judge had said, why don't you go back and come up with good search terms, that's not likely to be any more successful here than it was with the area where they were using search terms.
Judge, doesn't this quick case scream for tar?
Yeah, I was just going to say that, Tom. Great minds think alike. They could well have used tar, although the problem with tar here may be the distrust that the defendants will train the system appropriately or choose, what they mark responsive or not appropriately. But other than that, yes, I think it is.
Yeah, I certainly thought so too. We have a question from the audience. Doesn't Judge Nye's ruling to produce entire email mailboxes violate Rule 26B's scope that limits discovery to evidence that is relevant to any party's claim or defense? There's no way a custodian's entire email box is relevant. Thoughts?
I
mean, yes, that is correct.
Who's going to file that motion, right?
Yeah, you can't really appeal from the judge's order other than mandamus. There was a decision out of a district court in the Third Circuit, if I'm remembering right, where because the parties were fighting, the judge just said, produce it all, and other than pulling out privileged documents, stop this nonsense, produce it all. And they took mandamus to the Third Circuit, which affirmed, and they tried to get the Supreme Court to take it on further mandamus. And the Supreme Court said, in essence, what are you kidding? I'm not getting involved in this. So I suppose an argument could have been made, okay, we'll pull the entire mailbox. And since we're doing manual eyes-on review of everything, we will sort relevant from non-relevant, and perhaps give samples of the non-relevant to the plaintiffs or whatever it may be. But, this may again be a rule 1.1. They were pissing off the judge. He did the best he could, and that was it.
Great point, and certainly very interesting ruling that we'll certainly have more to talk about. We are past time here. I don't have time to get to other questions, unfortunately. Thanks for the several great questions we have gotten. So I will move to our contact slide, and we do already have a date for our next case law webinar, which is on Tuesday, May 24th. And the link is there in the attachments, so you can sign up for it right there if you would like to do so. And I will say that some of the evidence in a couple of the cases may go way back, which is a little hint about what to expect the next time. So with that, Mary, I will turn it back over to you to close us out.
Well, thank you, Doug. We so appreciate you anchoring, and we absolutely adore Tom and the Honorable Judge Peck for participating in this discussion. And our thanks to the EDRM community for your kind attention. So tune in next month, as Doug says, for our case law for May on the EDRM Global Webinar channel. And happy anniversary, Doug.
Yes, here, here.
We're here.
Thank you very much. And thanks to you, all of you, for your great comments as usual.